legal analyst Peter Elikann right now. Peter, as always, thank you for joining us. To begin here, what did you make of the judge's initial concerns, and did the defense do anything for itself as far as reasoning goes in the eyes of the judge there?
Yeah, they were a little upset about, a week ago when the judge talked about grave concerns, and this could have great implications for not just the defense, but the defense counsel. And it kind of left hanging out there. And they were particularly upset also that there was kind of no warning a week ago that the prosecution was going to do this. They didn't file a motion and give their arguments or affidavits or anything out of the blue. So they were left hanging for a week. And I think that they did help themselves, defense. They did help clarify things, that if the accusation is that they got paid and had all kinds of communications with these witnesses, and normally you can get paid by witnesses and you can communicate and pick your witnesses and go over material evidence with them and all that, but you have to be clear about that. You can't deny it or hide it, and that was the accusation against them. They are saying two things. Basically, that they had no input into what these witnesses were going to testify about. They had done the witnesses had done the report for the feds, and they said that was kind of set in cement. And the only communications they had were about sort of scheduling or about getting their biographies or background, and that was all. So no content. They said they had no input at all into what the witnesses were going to say. And they also said, as far as this payment, there was never any agreement to pay. You won't find anything. There's no evidence of that or communication in advance. They said out of the blue, after the whole trial was over, they got a bill and they called the feds, and they said, well, do we pay that or what? Because they thought that this was done for the federal government. And so anyway, they got their side of the story out. That's the defense version. And now I think testimony's still going on. The prosecution is now trying to rebut them. And it's getting rather personal. They're both talking about giving misstatements and kind of questioning the ethics of each other. So it is getting kind of personal.
Now, when you talk about misstatements, what happens in cases like this? Do they have to say what is actually the fact? Like, what happens with that?
Well, yeah, obviously every lawyer should be truthful and honest and not make any misrepresentations, particularly if it's in front of a jury. So they're held to, we lawyers are held to very, very stern, strict ethical standards. If you violate those, there's all kinds of sanctions. I mean, I don't know about this case, and I don't want to get ahead of myself here, but certainly a lawyer can be, you can face, all kinds of discipline from the bar, or there are questions about how that affect the prior trial, if it was done during the prior trial. Yeah. So there's all kinds of severe consequences, particularly with the bar.
Peter, as always, thank you so much for your insight. And you at home, remember that NBC 10 Boston, we will be your home for the Karen Reed case. You can join us for a special edition of Canton Confidential tonight at 7 o'clock right here on NBC Boston.